Hello, everybody. It's attorney Laura Sterling, and welcome to my live show. And yes, I am broadcasting out of Florida. And yes, there is a hurricane coming today. So we're going to make this short and sweet. Right now, it's not bad. It has been raining off and on. As you know, what do I want to say? I broadcast out of Orlando, and that's central. And we always get something, no matter what part of the state it hits, we get something just because we're central Florida. But it has been raining some, but right now it's not raining, at least where I am. Of course, here in Florida, it could not be raining where I am, and a block over it's raining. So you never know. But we're taking care of things. We're making sure we're safe. So if you're watching me from Florida or Georgia or wherever this hurricane's going to hit, be safe, take care of yourself, and just say a little prayer for all of us out there. So anyway, I wanted again welcome you to my live. As you're aware, this month we're working on guardianships. And so guardianships, now my last live, which was a couple weeks ago, we talked about incapacity, meaning when somebody becomes incapacitated. And what does that mean? Well, in court, it means they're adjudicated incapacitated. You're taking away somebody's rights. And so that's a pretty big deal. So again, they go through the three examining committees, members who go out and evaluate them, submit their reports, giving their recommendation. The court looks at those recommendations, see if there's any objections from, the court-appointed attorney for the person who they're taking the rights away from. Now, that person can, of course, object, which I've had often, and then we deal with that. So they've been determined incapacitated at this point. Now we jump over, because what happens when they're determined incapacitated, that case closes now. So that case is no longer, what do I want to say, viable or alive. It's now closed. The person is totally incapacitated, and we walk on over to the guardianship section. The guardianship case. See my lovely little overlay there. Guardianship. What is a guardianship? When somebody has been determined incapacitated, no matter what level it may be at, we cannot just leave them out there without somebody to take over those rights. So we can't just say, the court can't go, okay, I determined Laura Sterling as incapacitated. Now somebody has to be there to deal with my medical, to deal with my financial, all of that, because I don't have those rights anymore. I'm like a child. And so that's why we go over quickly on the same hearing, go to the guardianship case and say, okay, who's applied to be the guardian? Now, when I say applied, that's exactly what I mean. There is an application that the guardian has to fill out. It's like a job application they complete, saying these are their qualifications to be the guardian. And then also they put their social security. Guess what? The court has to check their credit, because if they have awful credit and they want to take care of somebody's finances, the court may not approve that. Also, what the court does, fingerprints. In other words, you cannot be in the state of Florida now. I don't know what it's like in other states. You cannot be convicted of a felony. So my first question I always ask family members that want to be a guardian is, have you ever been arrested or convicted of a crime? Because I want to know, okay, if they were misdemeanors, it doesn't automatically disqualify them, but it could if it's like petty theft or forgery of a check or whatever it may be. So it could disqualify them that way. Hi, Mariana. Oh, look at that. I love your abstract there. That's beautiful, by the way. Hi, Miss Sterling. Thank you for the weekly information. Of course. Quick question. Who can be a guardian? How is that person selected? Excellent question. Who can be a guardian? When we look, who can be the guardian? Now, generally, the guardian is somebody who knows you. You would hope it's somebody that knows you, a family member, a friend, an acquaintance, somebody that knows you that can make those decisions for you. Anybody can apply to be your guardian. Now, let me give you, which is a very good question, Mariana. Let me give you a little precursor with that. If you are a family member, if you are related by consanguinity, meaning if there's some blood connection there, you do not have to reside in the state of Florida to be the guardian. You can live in New Jersey, New York, California, Minnesota, wherever. you can be the guardian. However, if there's no line there, if there's no consanguinity, no bloodline, you have to live in the state of Florida. So my friend Kimmy from high school, love you, Kimmy, who lives in Minnesota, could not be my guardian down here in Florida because she doesn't live in Florida. My brother, Dale, love you too, Dale, who lives in Minnesota, he could be my guardian because he's my brother. So very good question. And I'm going to tell you how they're selected. They have to not be convicted of a felony or some other disqualifying criminal activity that the judge doesn't feel you'd be a good fit. Good, not good, not great credit, and not, it can be fair credit. I've seen a lot of judges, they give that a little leeway. Okay, well, people sometimes are late with their credit card payments. It's a given. So that's the individual of who can be a guardian and how they're appointed. So that great question, Mariana. So that judge then reviews everything, reviews the credit report, reviews the criminal background check. And so if they pass all of that, then they become appointed as a guardian of that individual. So great question, Mariana. Thank you so much for asking that. So they're appointed as a guardian. Now, yes, you can be the guardian, Mariana. Good question. You can have more than one person. I just had a client who they're getting guardianship over their aunt call and say, well, can we be the guardian of the uncle? Sure. Again, that's their choice, knowing that it's a lot of responsibility. But we also have somebody called a professional guardian down here in Florida, and I'm sure every state has them, where they're bonded, they're licensed, they're overseen by the Office of the Public and Professional Guardian. They can also be the guardian. They've already been qualified. They have to get fingerprinted. They have to do all that. So they've already been qualified, and they can have several wards as long as they can handle them, as long as they take care of them. Yes, you can have more than one person. So good questions, Mariana. You must know a lot about guardianships. So the guardian gets appointed. What is that guardian's job? And this is what I always tell my clients. I say, when you become the guardian of somebody, you become them. You are now them. You can talk to the banks. You can talk to the doctors. You can talk to their 401k provider. You can talk to their mortgage company. You can do all that because you're going to walk away with a nice little court order that says you are now the guardian. And you just provide that to Social Security, to whomever, certified copies, and you can now have access. Now, not to say that we don't have difficulty sometime with some banks that want to give us a hard time about these court orders, but I always have a little chit chat with them and then we get on the same page. So that guardian now becomes you. Their responsibility is you. They don't have to personally take care of you. They need to make sure you're in an appropriate setting, that you are taken care of. They don't have to pay any of your bills out of their pocket. They have to make sure that you have the money to pay that, or they get you on public assistance so that can pay it. So that's a big question I get a lot of time from my guardians. They also have to do an annual report, an initial report, an accounting, an inventory, all of that kind of stuff. So sometimes I get family members in and they want to, I want to be the guardian of my mother. I love her, all this. It has nothing to do whether you love them or not. It's a lot of work. And I tell them that. It's a lot of work. I one time had a wonderful son. He was beautiful with his mother, and he was a guardian of his mother. And he finally came to me after a year and said, I can't do it anymore. And we ended up getting a very good professional guardian who took very good care of his mother with input from him 100%. So know also that there are different levels of guardianship. It can be the full-on guardianship, meaning the person was found totally incapacitated. They cannot make any decisions. So that is a plenary, we call it. Plenary. Plenary means total guardianship. I have person, property, everything. Or it can be limited, where I'm just the guardian of the property, or I'm just the guardian of the person, whatever it may be, whatever that person is determined in court to need based on the examining committee reports and based on any testimony or evidence. So that's it. That's a guardianship. And the guardian is the guardian for life, unless a couple things happen. One, the person passes away, God bless them, or the person regains their capacity. And we do something called a suggestion of capacity, and a doctor's appointed to go back out and see them, and maybe they get their rights back. And we have done that in quite a few cases. And it is actually a very nice thing that they were able to get their rights back and be able to do their own decision making. So again, I'm glad you joined us. Pray for us here in Florida and beyond with the hurricane coming. And if you're listening to me from any of the states that the hurricane's going to hit, please, please, please be safe. We're here for you. Please give me a call if you have any more questions about guardianship. We'd be more than happy to help you with those. The guardianships, we do them all the time. We do them throughout the state of Florida. So please feel free to give us a call. We're here to help. And God bless and be safe.